Thanks, Kathy, and hello, everyone. Good afternoon. I'm happy to be with you today. My name is Teresa Resnick. I'm an attorney in the Labor Department in Bond's Rochester office, and I will be your guest host for this afternoon session. We have a great agenda for you, so Kathy, if we could just go to the next slide. First up is Tom Eron. He's an attorney in our Syracuse office. He's going to be talking about the National Labor Relations Board and their recent ban on captive audience meetings. It's a very interesting development. I know I'm looking forward to hearing about it. Next up, we're going to have Kelly McKinney. She's an associate in our Labor Department. She will be talking about the Supreme Court review of reverse discrimination pleading standards. Another interesting one, particularly, I know there's a lot of interest around the topic of reverse discrimination. Then we're going to have John Riley. He's in our immigration practice group. He's going to be doing an immigration law update for all of us. And we'll end with Carrie Langen in our labor and employment group, who's going to be discussing a new FMLA opinion letter. I know for most of us, the Family Medical Leave Act is an important law that is ever changing and always important. Any questions I will try to keep mindful of as we go through. As Kathy said, please put them in the Q&A. And with that, I'm going to turn it over to Tom Eron to talk to us about the captive audience meeting.
Thanks, Teresa. Appreciate it very much. Good afternoon, everyone. So we know that the National Labor Relations Board has been very active, and this most recent decision involves Amazon and the union organizing activities at its warehouses in Staten Island, New York. So as Teresa said, it concerns captive audience meetings. Well, what's a captive audience meeting? This arises in the context of a union organizing campaign, and it's a label that's been given to meetings conducted by the employer. So in other words, a meeting scheduled by the employer on work time, at which employees attend and employer representatives provide their opinions and factual information relevant to the union organizing effort. Typically, these arise once the NLRB election has been scheduled and the employer is providing factual information and opinion to its employees. In the Amazon case, the employer held these meetings, and the current general counsel has this new theory that she pushed forward and has been presented to the board, and now the board, and this is the full board, not a panel, but all four members, with the obviously the Democratic member dissenting. The board found these meetings to be unlawful, and you need to appreciate the historical context here, right? So in 1946, the NLRB reached a similar decision that so-called captive audience meetings would be unlawful. In 1947, 1 year later, Congress amends the law and adds what's referred to as Section 8C, which codifies the concept that the employer can speak to its employees about union issues, so long as the speech is not coercive or threatening. In response to that legislative change, the board reconsidered the issue in 1948 and decided that captive audience meetings were lawful, with one minor exception. In the 24 hours prior to the start of the election, the board recognized that at that late date it would be difficult for the union to counter anything the employer said, so they precluded captive audience meetings in that 24-hour period. But that was a law established in 1948, and it's been the law since then. What's that, 76 years, right? Settled law, everyone understood what the rules were, and we proceeded accordingly until this administration decides that we need to change this settled law. And in this decision, the board articulates a couple of reasons for finding these meetings unlawful. One is that it forces the employees to listen to the employer. The board has this phrase that it uses, on pain of discipline or discharge. And that is the hook that it relies on to find this conduct unlawful, coercive. The board also comments that because of that underlying quote unquote coercion, the employees are likely to give more emphasis or more consideration to the employer's speech. Hard to see how this decision withstands scrutiny on appeal, given the settled nature of the law for so long, and without any other change in the law that the board can apply new concepts and significantly reverse what has been in place. So why is this significant, right? So obviously disrupting settled law. I kind of put a footnote there because I would say the market has corrected already for this. This concern has led to many consultants advocating for voluntary meetings. And in fact, in the decision, in the Amazon decision, the board, in sort of a legislative mode, writes this language on what would be a quote safe harbor, a voluntary meeting under conditions that the board articulates. But as I said, that has been moving in that direction, independent of the board's decision. What's really significant here is this is a continuation of the current general counsel's very aggressive agenda to change the law, and obviously to try and get in as much as it can before the change in administration, when we anticipate very significant changes in the direction of the agency. But keep in mind, these board members are appointed for 5-year terms. And so it is likely to be at least a year and a half or more before there's a change in the majority of the board. And as we know, it takes some period of time for these cases to percolate up to the board. Now, it wouldn't surprise me if the general counsel changed very quickly, but the status of the board may take longer to change with the new administration. And as I said, I get concerned about this theory that because something is subject to discipline, that it is inherently coercive. And where does the board go with this, right? And we've seen this acceleration of the implementation of the general counsel's positions with the Starbucks decision earlier this month, and the general counsel's memo on the stay or pay provisions, challenging those as potentially unlawful. And the last thing I'll mention is that the general counsel's view is this principle of coercion, inherent coercion, if we want to call it that, can be applied in the impromptu one-on-one conversation between a supervisor and an employee. So in other words, really handcuffing the ability of a supervisor to speak to an employee on issues that affect not just unionization, but the whole concept of or penalty of Section 7 rights. And the board specifically said in a footnote in the Amazon case, they were not going to go that far here. But that is definitely on the agenda. If that case is ripe, it's very easy to see the board, this board, as it exists today, curtailing the ability of individual supervisors to engage with individual employees. Haven't done it yet. It's not in this case. It's specifically reserved, but it's something we have to really keep our eye out for, because that could upend a number of circumstances beyond just in the union organizing context. And once the decision is made, of course, it's subject to appeal and so forth, but it puts a stake in the ground. and would force the board, as it becomes constituted under President Trump, to go back and undo what this board has done and leave us in legal jeopardy, until that time. So my crystal ball says we'll see more decisions by the board in the next several months to try and get as much of the current administration's agenda accomplished before the change in administration. So stay tuned. With that, I'm going to flip it back to Teresa. Thank you.
All right, thanks, Tom. That was great. We certainly appreciate it. With that, I'm going to turn us over to Kelly McKinney to talk about the reverse discrimination standards at the Supreme Court.
Thanks, Teresa. Hi, everyone. So as Teresa just mentioned, I'll be discussing a case that the Supreme Court has decided to review regarding the pleading standards for reverse discrimination claims. Next slide, please. So reverse discrimination is the unfair treatment of members of the majority group based on their age, sex, race, or other protected class. This is unlawful under Title VII, which prohibits employment discrimination based on protected characteristics. An example of reverse discrimination is an employer hiring a female applicant over a male applicant solely because of her gender, even though the male applicant is more qualified. Next slide, please. So to plead a claim under Title VII, where there is no direct evidence of discrimination, a plaintiff has to establish 4 elements. 1, that he was a member of a protected group. 2, that he was qualified for the position. 3, that he suffered an adverse employment action, such as a termination or a demotion. And 4, that the adverse action took place under circumstances that give rise to an inference of discrimination. This is typical in all Title VII claims, regardless of the circuit. This is the general pleading standard. Next slide, please. However, some circuits impose an additional requirement for plaintiffs who are members of a majority group. For example, a plaintiff who is white and claiming race discrimination, or a male claiming sex discrimination. In those cases, in addition to the typical 4 elements of a disparate treatment claim under Title VII, the plaintiff must also show background circumstances to support the suspicion that the defendant is the unusual employer who discriminates against the majority. Next slide, please. So in a recent Sixth Circuit case, Ames versus Ohio Department of Youth Services, the court there discussed this additional requirement. There, the plaintiff was a heterosexual woman who held the title of administrator and then applied for a promotion to bureau chief. So first, she was denied the promotion. A gay woman received the promotion instead of her. And then she was demoted from her current position and was replaced with a gay man. Next slide, please. So the plaintiff brought a lawsuit against her employer, claiming that she was denied the promotion and demoted from her current title based on her sexual orientation in violation of Title VII. So as is typical, the court applied the usual 4 elements of a Title VII claim and found that she met her burden. So first, her claim was based on sexual orientation, which is a protected category. Second, she was qualified for both positions. Third, she suffered 2 adverse actions. She was not promoted and she was also demoted. And fourth, she was replaced by a gay man after her demotion, and a gay woman received the promotion that the plaintiff sought, which are facts that could give rise to an inference of discrimination. However, because heterosexual individuals are the majority in the Sixth Circuit, the plaintiff also had to meet the background circumstances requirement. In other words, she had to plead facts that showed her employer was the unusual employer who discriminates against the majority, which here is heterosexual individuals. The court, however, found that the plaintiff failed to do so. Next slide, please. The court explained that in cases where there is no direct evidence of discrimination, a plaintiff claiming reverse discrimination meets this burden by presenting 2 forms of evidence. 1, either evidence that a member of the relevant minority group made the employment decision at issue. So here that would be a gay individual. Or 2, statistical evidence of a pattern of discrimination by the employer against members of the majority group. A plaintiff, however, cannot use their own situation to establish this pattern. There must be other examples a plaintiff can point to. Next slide, please. So in this case, the Sixth Circuit held that the plaintiff failed to present evidence of either. First, there was no evidence that a member of the relevant minority group, here gay individuals, made the employment decisions at issue. Instead, the two decision makers for both the promotion and the demotion were heterosexual. Next slide, please. And second, there was no statistical evidence that showed a pattern of discrimination by the employer against heterosexual individuals. Instead, the plaintiff only proffered her experience as evidence of such a pattern, and this wasn't enough. Next slide, please. So currently, 5 circuits require this background circumstances test when they evaluate reverse discrimination claims. These are the 6th, 7th, 8th, 10th, and DC circuits. The 3rd and 11th circuits have expressly rejected this test, and the remaining circuits, including the 2nd Circuit, which reviews New York cases, have not applied the test. So due to this split, the United States Supreme Court has decided to hear this case in its current term. They will ultimately decide the issue of whether these majority group plaintiffs in all cases across the country have to show these background circumstances to sustain a claim of discrimination. Next slide, please. So if the Supreme Court decides that background circumstances test does not apply, it's going to be easier for majority group plaintiffs to pursue discrimination claims and will most likely result in an increase in these claims. Likewise, if the Supreme Court finds it does apply, majority group plaintiffs everywhere will have an additional hurdle to sustain these claims, namely whether or not the employer, there are facts that support that the employer is the unusual employer that discriminates against the majority. Thank you.
All right, thanks, Kelly. We appreciate that. I'm going to turn us over now to John Riley to talk about an immigration law update. John, please take it away.
Thank you very much. Good afternoon, everyone. And as Teresa said, my name is John Riley, and I work in the firm's immigration practice group. Currently with the election, we're getting bombarded with questions from employers and clients about how the immigration system will change under a Trump administration. And the thing that I keep telling clients consistently, and the main point that I want you to take away from today's webinar, is that other than the administration's plan to focus on mass deportation of undocumented workers, we don't really know anything concrete. And anybody telling you otherwise is purely speculating, and it's causing a lot of panic, within the employer and foreign national community. So I would really like to highlight that, as of today, November 19th, we don't know any policy that will affect documented foreign nationals who are currently employed in the United States. So it's good not to overreact. And as we saw in Trump 1.0, they had plenty of proposed policies and ideas that they talked about implementing, but they never did. There's legislative hurdles, there's bureaucratic and administrative hurdles. And they're political hurdles to getting these things done. So, it's best to kind of sit back, wait for official policy announcements from the administration before changing or deciding on any course of action with respect to your employees. So as of today, again, it's November 19th, a couple weeks after the election, our advice to employers remains the same as it always does, and that's to follow standard best practices and ensure your company is in compliance and your paperwork is in order. So this would include things like reviewing your employees' I-9 forms to make sure they conform and they're complete and accurate and filled out and don't have mistakes on them. This would include things like maintaining public access files for H-1B employees, making sure they're up to date and readily accessible if and when the government decides to show up for an on-site inspection. And we typically advise clients to have a specific individual within the company to manage interactions if there is a government audit. I've been doing this for 15 years and I've only seen an audit once. So they're not frequent, but they do happen and they can have consequences. So, we recommend as a policy to have a person who knows what to expect, knows where the files are. And just so you don't have like a random employee answering questions that could inadvertently affect one of your foreign national employees. And, finally, avoiding speculation. We don't think it's helpful at this point to speculate as, to what's going to happen. We will monitor announcements. You will monitor announcements. Clients that have questions, feel free to come to us. We will post things publicly as we come to know them. So now that you know that we think it's not appropriate to speculate, maybe we could speculate a little bit, knowing that you have to take it all with a grain of salt. So, what things happened under Trump 1.0 that might come back? Well, under Trump 1.0, we saw a very significant increase in requests for evidence. This is in particular categories like H-1B and L visa employees. So, these types of cases, again, they've required extensive documentation for decades. Okay, but they really were quite difficult during that time period. But again, the advice to clients is the same. We need to extensively document what we're submitting and make things very, very crystal clear when we submit the paperwork. And again, we saw an increase of denials during that time. Again, this was typically in the H-1B category for kinds of occupations that had traditionally been approved. We saw a lot of pushback on this. So again, we extensively document all these petitions that are filed. One policy that happened under the Trump administration that was reversed by the Biden administration is under Trump 1.0, USIS stopped giving deference to prior petition approvals. So this meant if you had an employee in H-1B or L or some non-immigrant status and you were extending their status for an additional 2 or 3 year period, USIS could deny the case and just ignore the fact that it had approved the same petition for the same employer, the same employee, the same job title, the same job duties a couple years before. It's absurd. I know, but this was their official policy. And even though under Biden, they say it's not their official policy, we've seen, pushback. So I would expect that that probably would happen again. Trump 1.0 also had an extreme vetting policy. I mean, this is well known. So, workers from, countries such as Iran face heightened background checks. We did see some, denials at the border for people with certain, who are from certain countries, especially if they had military service. And we saw but we saw some delays in getting security approvals for people from certain countries or travel to certain countries with the State Department. We also saw a slowdown in green card application processing last time under Trump because they started requiring interviews for employment-based cases. Again, this was reversed under Biden, but this was, one of the things that they implemented, that really kind of slowed things down. It was just a pain and not really helpful. So hopefully they won't bring that back this time, but we'll keep an eye on that as well. And then one of the things that they implemented last time that they've continued under the Biden administration is checking social media profiles and public profiles of employees. So, this would include things like people's LinkedIn profiles. So if you have an H-1B worker or an L worker, and they're a project manager, and they have certain duties and they work in a certain state, but their LinkedIn profile says something different. Like these are things that can raise red flags, and they're easily accessible when DHS is reviewing a case. So, we think it's best practice to make sure that your employees, use the same job title. If they put what they do at the company on their public facing profiles, that they use what we submitted with the H or L petitions just to make sure everything is consistent. And a lot of times these just aren't updated, okay, but it can cause problems because the government checks these pretty carefully. Are these policies, possible that they're returned? Absolutely. Do we know for sure? No, we don't. So again, it's best to wait and see what happens between now and when the new administration is sworn in. They'll probably put out some policy announcements. We will start to get feedback from cases that are currently pending or pending during that period, and then we'll be able to provide better specific advice about what they are going to do with documented employees. Okay, so again, the key takeaway for today is we don't know much in terms of documented employees, and it's really best to not speculate or panic. Hopefully, the administration, if they're going to put the hammer down, they do it. They're, as they said they're going to, on undocumented workers. And hopefully, because illegal and legal immigration get mixed up politically, hopefully if they do that, they'll be more reasonable and more efficient with, employment-based immigration. And hopefully they'll be able to do that. So in the meantime, best not to speculate, take a wait and see approach. If you have any questions for us, we're happy to answer them. And as soon as we know more information about what their official policies are, we'll tell you. And that's all I'm going to say for now. And thank you for listening.
All right, thanks, John. We appreciate that. That was very informative. And with that, I'm going to turn us over to our final presenter, Carrie Langen, who's going to be talking about a recent FMLA opinion letter. Carrie?
Thank you, Teresa. Good afternoon, everyone. I just wanted to report on a recent DOL opinion letter. So on November 8th, the United States Department of Labor issued this opinion letter, and it addressed whether an employee could use leave under the FMLA for treatment of a serious health condition when the treatment's provided as part of a clinical trial related to the individual's serious health condition. So a somewhat interesting issue. The DOL concluded in this opinion letter that this was permissible use of the FMLA. So for those of you that may not be as familiar with the FMLA or who need a refresher, the FMLA provides eligible employees of covered employers with up to 12 weeks of unpaid job protected leave in a 12-month period for certain qualifying reasons, one of which is the employee's own serious health condition. And the FMLA defines serious health condition as an illness, injury, impairment, or physical or mental condition that involves either one, inpatient care in a hospital, hospice, or residential medical care facility, or the second is continuing treatment by a healthcare provider. So the DOL here was focused on the continuing treatment piece. And they explained in the opinion letter that the FMLA regulations define treatment and continuing treatment very broadly, such that the DOL concluded that the fact that treatment associated with participation in a clinical trial is considered optional, voluntary, or elective is not a factor in the determination of whether the employee can take FMLA leave to receive treatment. Similarly, the DOL also concluded that it's not relevant whether a course of treatment is new, experimental, a placebo, or proven to meet certain criteria for efficacy. The DOL pointed out that the FMLA law and regulations don't require or permit an employer to ask about the effectiveness of treatment to determine whether an employee may take FMLA to receive the treatment. So in the opinion letter, the DOL provided two examples to illustrate these principles, and I think the examples are really helpful, so I'd like to go over them briefly. The first is as follows. So Janelle has sarcoidosis, an inflammatory autoimmune disease that affects her breathing. She receives treatment for this condition at least twice a year, and as such, the condition qualifies as a chronic serious health condition under the FMLA. And Janelle otherwise meets the FMLA eligibility criteria. Janelle is interested in volunteering to participate in a clinical trial for the treatment of this condition, but is concerned that if she changes her current treatment plan, the amount of time she needs to take off work may change. Under the FMLA, Janelle may use FMLA leave to receive treatment in the clinical trial and recover from treatment, including if there are changes in treatment or in her response to treatment due to her participation in the clinical trial. And the second example is as follows. Bernard has cancer and is participating in a clinical trial for a new drug intended to help patients manage side effects from chemotherapy. Bernard meets the FMLA eligibility criteria. In the clinical trial, Bernard does not know whether he has been prescribed the new drug or the placebo. Bernard may use FMLA leave intermittently for time spent receiving chemotherapy and participating in the clinical trial, including recovery time. So I guess, what are the key takeaways here? Employers should keep this decision in mind for a few reasons. So first, as many of you already know, when an employer acquires knowledge that an employee's leave may be for an FMLA qualifying reason, the employer is required to notify the employee of their eligibility for FMLA within 5 business days. So if an employer becomes aware that an employee needs time off from work due to their participation in a clinical trial, the employer should recognize there that, hey, this could be FMLA qualifying and notify the employee of their eligibility for FMLA. And the second takeaway in light of this opinion letter is that employers shouldn't question the FMLA medical certification form if it indicates that the employee needs FMLA to participate in a clinical trial on the basis that the clinical trial is considered voluntary or elective. That the employee maybe doesn't need to do this, right? They're choosing to participate in this trial, and that somehow this would disqualify them from receiving FMLA for that purpose. So that's really the basis of this DOL opinion letter. As always, please feel free to reach out if you have any questions about the opinion letter or FMLA generally. And with that, I will turn it back over to Teresa. Thank you.
All right, thank you, Carrie, and thank you to all of our presenters. I did notice that we had a couple of questions, and we do have a little bit of time. The first question appears to be for Tom Iran. Tom, if you're still with us and you're able to shed some light on the question, whether or not the captive audience changes affect an employer's ability to meet with leadership teams, or if it just applies to potential bargaining unit employees.
Well, thanks, Teresa. The answer to that is it does not impact the communications within the management team. But I say that and caution folks, because when we get down to the level of first line or frontline supervisors, right? Team leaders, group leaders, we need to be very careful about distinguishing between those who are truly supervisors under the statute or members of management and those who are not. And just because someone has some indicia or some responsibility that is supervisory, they may still be considered by the labor board as a rank and file employee. So when you're talking with your management level folks, there's no impact, but we do want to be careful in how far down the ranks you go in engaging in those conversations. And that's something very fact specific, and the folks need to work out with their counsel based on the particular facts that they're addressing and the information that they want to share. I hope that's helpful.
I think that's great, Tom. Thank you so much. Carrie, there appears to be a question for you as well about continuing treatment with no hospitalization. Does that equate to a period of incapacitation? And does the continuing treatment mean more than one appointment? Any light you want to shed on that, I'm sure would be appreciated.
Yeah, sure. I'm happy to do that. So keep in mind, right, there is the incapacity plus treatment prong, which is the continuing treatment. And then there's the hospitalization. And there are two separate ways that you can establish that portion of the definition of serious health condition. So with the continuing treatment prong, there does have to be an initial period of incapacity, which is really time away from work, and a period of, or a treatment within 7 days of the first day of the period of incapacity. So I think that answers the question, Teresa. Was there any other aspects that I didn't answer?
No, I think that's great.
Okay.
Thank you, Carrie.
All right.
And hopefully that answers our attendees' question. As always, you can feel free to reach out to any of our presenters or to me or any bond attorney that you work with if you have follow-up questions on anything that we present on the webinar. We're always happy to have that dialogue with you. I did see a number of questions about the federal court blocking the minimum salary threshold. We had a decision recently out of Texas. The federal court blocked some FLSA salary threshold changes. I'm I'm not going to speculate. I think John had hit the nail right on the head. You know, will that be appealed by the Biden administration? Possibly. Will the Trump administration continue to pursue that appeal? Likely not. Those are just my thoughts on that. For those of us in New York, I believe the salary threshold is still set to increase for certain types of exempt employees. As usual, we'll have one threshold for downstate and one threshold for upstate. Just a quick review, it looks like the salary threshold as of January 1, 2025 for upstate exempt employees is going to be $1,161.65 per week to meet that exemption. Remember, when we're talking about an exempt employee, they need to meet both the salary test and the duties test to be considered exempt. Again, any questions about that, feel free to reach out to me or any one of our bond attorneys. We're happy to address that as well. So with that, I think I'm going to wrap up our webinar today. Thank you all so much for your attendance and time. We appreciate it. And until next week, have a great week.